A representation is a statement of fact. It's not a statement of intent or a statement of law or a statement of opinion. It's just a statement of fact, a present fact or a past event, nothing to do with the future. It may not form part of the contract, the sale and purchase agreement, but it is an inducement which induces the buyer to enter into the sale and purchase agreement. And if it's false, it's a misrepresentation. A representation is true, a misrepresentation is false. It may not appear in the agreement unless it's brought specifically into the agreement. So say I'm selling you a hotel, for example, and I represent to you this hotel has a sea view. That's a statement of fact. It either has got a sea view or it hasn't got a sea view. Now, if you go ahead and buy the hotel without bothering to look at the hotel before you buy it, and you buy it and you find it hasn't got a sea view, you can then get some compensation off me. You can sue me for the misrepresentation. I said it had a sea view, and it hasn't got a sea view. And you can either claim damages or rescission, which means you tear up the contract and the parties go back to their original positions, which I'll talk about in a moment. But it has to be a statement of fact. If I represented to you before you bought the hotel that the hotel has an extremely attractive view, and you buy the hotel without looking at it, and you discover it's got a simply appalling view, although my representation was not exactly true, it's a statement of opinion, not a statement of fact. Therefore, you can't sue me for that. You can only get a compensation back from me if my representation is a misrepresentation of fact or a past event. Now, the representation, as I said, probably won't appear in the contract, but it's not part of the contract unless it's warranted. If you want to bring a representation into the contract, you ask the seller to warrant the representation. That's important because if the seller's properly advised, they will have what's called an entire agreement clause in the contract, which will say, unless something is in the contract, it doesn't count. So if I've represented to you the hotel has a sea view, it's left hanging out there. It's outside the contract unless you ask me to warrant it, which brings it into the contract. Now, what a warranty is, it's a guarantee. So I represent to you the hotel has a sea view. That's outside the contract. You bring it into the contract by asking me to warrant, to guarantee it has a sea view. Now, warranties are absolute. They're absolute guarantees, and then they are qualified by the disclosure letter, which I'll talk about later, whereby the seller will say, well, this is what I guarantee, but it's not a complete guarantee because there are various exceptions, and that appears in the disclosure letter. Now, going one stage further, the buyer can ask for an indemnity. Now, an indemnity is an undertaking. The parties agree a set of circumstances which they believe to be true. And if those circumstances turn out to be untrue, and one party suffers a loss because those circumstances were not true, the first party undertakes to put the second party back into the same financial position they would have been, pound for pound, as if it was true. So you get put back in the same position. Now, as part of the general definitions then, just to set the scene, there are three main differences between warranties and indemnities which you need to know.